The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome today. My name is Wayne Ann Caudle. I am with the Long-Term Care Ombudsman Program with Legal Aid of the Bluegrass.
My name is Amanda Hamilton, and I am also with Legal Aid of the Bluegrass Long-Term Care Ombudsman Program.
I'm the Gateway Ombudsman, and Amanda is the Five Co Area Ombudsman. Every October, we celebrate Resident Rights Month. It's a special time we set aside to make sure that we focus on the rights of residents in long-term care, because those rights are very important, so important that we've enshrined them in law. And so today we just want to talk a little bit about some of those rights and why they're so important. I want to start talking today about a key resident right, and that is the right to choice. So let's go to our first slide. Residents have the right to choose. They have the right to choice. Residents have the right to choose how they want to live their lives, from big choices to small. You know, the power lies with the resident. And that sounds great, I know, but what does that look like in the real world? Well, let's break it down. On a daily basis, residents have the right to have their day the way they want. What I like to say is you have the right to your day, your way. Residents have the right to make decisions about how their days look. They get to choose what time they get out of bed and what time they go to bed. We hear a lot of times that residents like to sleep in, and I will just say that I don't blame them one bit. But sometimes we'll get a call from someone that, every morning staff will wake them up at some crazy early hour because they need to take a medication, or they get woken up early because staff is delivering breakfast. If a resident wants to sleep in, their doctor should really help facilitate a medication schedule that would let them do that. It's as simple as getting them on a new schedule. And just because everyone else is eating breakfast doesn't mean the resident has to. The facility should keep a plate warm for you. We also hear about folks getting up at very strange hours just because that's when staff are available to give showers. I don't know many people who like a shower at 3 or 4 in the morning, but we sure do have a lot of residents who tell us that's when they take their showers. And if a resident wants their shower at 3 in the morning, then that's absolutely when they should have it. But otherwise, showers should really be given on the resident's schedule, not the facility schedule. Residents also have the right to go where they want, when they want. Sometimes this means they leave the facility to go visit someone. Sometimes it means they just want to go take a walk. Unless the resident has a legally appointed guardian, they have the right to do whatever they please. We sometimes get calls from a worried staff member that a resident says they're going to leave the building, but they won't tell them where they're going. They don't really have to. They have the right to privacy as well. Residents definitely need to let the facility know that they are leaving the building. That's a safety measure for sure. But they don't have to tell anyone where they're going or what they'll be doing. And when we get those calls, we understand that the facilities, are worried about the safety of residents. So we always kind of say the same thing. If you think a resident is in danger by leaving the building, you have a responsibility, if you really think someone's going to be hurt, to call Adult Protective Services and possibly even the police. But if it's a simple thing, if you don't think they're going to be in danger, they have the right to privacy. It doesn't matter why they're leaving, and they don't have to explain that. Residents also have the right to make their own decisions. Medical decisions. Facilities have their own doctors, but sometimes residents want to keep the doctors they've had for years. And of course, that's understandable. Not many people know you better than your doctor. But I want everyone to keep in mind that you have the right to have your own doctor. Now, it's up to your doctor if they want to come to the facility to see you, and if they do make that choice that they're going to come to your facility to see you and treat you, they'll probably have to sign some paperwork, be approved by the facility to come in. It shouldn't be so, the paperwork shouldn't be so onerous that, you know, the doctors can't meet the requirements. But a lot of the times our doctors say, you know, they no longer make those kind of visits to facilities. And that's okay too. That's their call. Residents can still leave the facility. You can still go to your doctor's office. You can get some medical transport, or even a family member can take you if you're physically able to do that. So, you know, you can go out to your family doctor for appointments if that's what you choose. And the same goes for pharmacies. If you have a hometown pharmacy that you like, you can absolutely still use your hometown pharmacy. It is usually more complicated to do that, but it absolutely can be done. Residents also have the right to say no to any medication or treatment, even if it's a life-saving treatment. A resident has the right to say no. I want to close this section by talking about families and powers of attorney. You know, sometimes a facility will get a call and they'll say, you know, we've got a power of attorney or a family member that, you know, has told us this resident can't leave the building, or they're telling us that a resident has to have a shower on certain days, or sometimes they're not allowed, they're telling the facility that, you know, my mom's not allowed to have certain food because it's bad for her health condition. It's important to know that unless under specific circumstances, a family member or a power of attorney, they don't have the power of the resident's choice. They don't get to make those choices for them. Unless under very specific and limited circumstances, they just don't have the authority to make those decisions for the residents. And the families are coming from a good place. They're trying to take care of their loved one. But once again, the power of choice resides with the resident. Most of the time, only a legally appointed guardian can make these types of decisions. And even then, the law says that guardians are supposed to take into account the wishes of the ward to the fullest extent possible. Next slide, please. So the second right that we want to talk about is kind of a grouping of rights under transfer and discharge. We get a lot of calls about residents who have been told they're going to have to leave the facility, but they don't want to leave the facility. And there's a lot of reasons why. People under therapy who are in a facility for some short-term rehabilitation, they may feel like they still have some progress to make. There's all kinds of reasons that a facility may tell a resident that they have to leave. And that is basically an eviction, especially if you are in long-term care and you live at a facility. This is an eviction from your home. So one of the big things that we educate on with our facility is that there are only certain reasons that a facility may evict a resident against their will. Now, if a resident's ready to go home or they want to go to another facility, there's no problem. But if you don't want to leave, there are only certain reasons that you can be made to leave. And briefly, I just want to go over those. The first thing I will say is lodging complaints with your facility and pointing out issues that you have you will not see that on this slide, because that is not a reason for discharge. Okay, so asserting your rights and making your voice heard is completely okay at all times. So the first thing here, the first reason that a facility may legally evict a resident is non-payment. You have to pay your bill if you are a resident. There's just really no way around that. If you have applied for long-term care Medicaid and that application is pending, you shouldn't be discharged if that application is pending. If you are, the way the regulation reads, if you're attempting to get third-party payment, which Medicaid is, then they cannot discharge during that time. If you're worried because you feel like for whatever reason there's certain circumstances that you owe a huge bill and you're worried about getting it paid, call our program. There are many ways to get these long-term care bills paid. or get help with your payment. We can't promise satisfaction in every circumstance, but there are lots of ways that we can help you get those bills down and try to help get them covered and paid for. So don't ever let your payment status scare you from calling us if you feel like you need help. We have lots of ways we can try to help you. Another reason that a facility can possibly evict a resident is safety. For some reason, if the safety of other residents is in danger, or health, if for some reason the health of other residents is in danger by this resident staying in the facility. And I'm going to say, and I'll probably say this again here in a minute, if that's the claim that the facility is making, they're going to have to prove that. They're going to have to offer evidence that by this resident staying in the facility, the safety or the health of other residents is in danger. They can't just throw that out into the universe and that be all. And they have to prove this. Next, if a resident's health improves and they no longer meet the level of care, so you've been in the facility, you've made so much progress that you don't need their help anymore. Next, if the facility closes, if a facility decides to close, there's nothing you can do about that. However, I want to make sure that everyone understands, even if it's a facility closure, you should still have some notice. I don't know. I'm not saying it can't happen, but I'm not aware of a situation where someone comes to you on Tuesday, the facility's closing on Wednesday, and you've got to be out. You should still have some notice. Facility closures typically go through a specific process with the state. You should have a written notice. That's what I mean. Your notice should be written, and it should not be immediate. The next reason for eviction is that the facility cannot meet a resident's needs. And just anecdotally, I would say this is the one I get most of all. But here's the thing. A facility, if they're going to tell you that they are evicting you because they can't meet your needs, they must explain what need they cannot meet. Just like I said about safety and health, they can't just throw out into the ether, oh, we can't meet your needs, and then expect that to be enough. They've got to tell you what need they can't meet, and they must show how they tried to meet that need. They have to put some effort into that. And so when I'm telling you line or they must show these things, how do they explain and show those things? Well, that's the last bullet point there. A written notice is required. Anytime a facility is telling you that you have to leave the facility against your will, you're not ready to leave, and they're telling you you have to go, they have to give you a written notice. And they have to explain those things in the written notice. If they're telling you they can't meet your needs, they need to tell you what need in writing, and they have to show how they tried to meet it. Your notice has to meet certain requirements. It has to give you, most of the time, it's a 30-day notice that's required. Even when less, there's special circumstances that are not common when they can give you less notice. The notice should still be appropriate. Under very, 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 very few circumstances can they come and say, you've got to go tomorrow. That's not how, that's typically not how this works. And whatever kind of notice you get, whether it's 30-day, whether it's 10-day, whether it's whatever, you have the right to an appeal. There are no exceptions to that. You can appeal any notice, whether you've been in the facility 5 years or 5 minutes. You have the right to attempt to appeal your discharge. So these are some of your rights under discharge, and I just want to say, if you get a notice for discharge, if you have a family member who gets a notice, or if a facility just tells you, you've got to go, and they don't give you a written notice, make sure that we are your first call, because we can walk you through this process, and a lot of the times we can help you even appeal. One of the great things about legal aid is we have access to legal aid attorneys, and a lot of the times an attorney can help you appeal these decisions. At this point, with the next slide, I'm going to throw it over to Amanda.
The first thing that I wanted to discuss is the right of privacy. And privacy is so important for residents because this is their home. And you and I both enjoy, privacy in our own home. When I'm in my home, I expect a certain level of privacy. That's, our safe space. So residents have a right to privacy regarding personal, financial, and medical affairs. So essentially, this means no one should know anything a resident is doing or the private information without their consent. No one should know anything that a resident does not disclose to them personally or give permission for someone to disclose to them. No one should know without the resident's permission how much money they have, how they're paying for their care, or any other financial issues. As you and I like to keep our financial issues private, the residents have that same right. Others should also not know about residents' medical conditions, test results, medication, any other medical information without their permission. So this isn't something that staff should be discussing in the hallway where other residents can hear, or in times when families can visit, when families can hear any kind of information. HIPAA laws still apply that resident information should not be shared publicly. They have a right to medical privacy just as the rest of us. Residents have a right to private and unrestricted conversation with any person of their choice. And this is something that I think is so important right now because, with COVID, it has changed the way we're communicating. This means that residents should not be told they cannot talk to someone or see someone of their choosing. So, with COVID, this is different because in-person communication is largely restricted right now. So they should be able to have phone calls and FaceTime visits with the person they're choosing. Facilities shouldn't be making arrangements for this. And they should be able to have these conversations in a private space so that others don't know what they're discussing. When looking at this, a nurse's station is not an appropriate place for residents to have to hold their conversations. They should be able to, be given a cordless phone or cell phone, something they can take in their room, or they should be provided a private space. The regulations are very specific on what constitutes an appropriate place for them to have private communication. But they also have a right to privacy of who's calling them. So, this is always important, like I said, but especially right now with COVID, when all communication is through phone and video. Unless the resident is requesting the facility to, they should not be screening their calls. And by screening, I mean staff shouldn't be questioning who's calling the resident when they ask to speak to them, unless, there may be residents that specifically ask to have this in their care plan, but otherwise, they shouldn't be questioning people because, residents may have issues that they don't want people to know about. They may be calling us, the ombudsman. They may need to have, other kind of private conversations that they just don't want people to know about because they, fear the impact that it can have on them. And, they may have other reasons. For myself in my own home, I don't have anybody that knows who I'm talking to, when I'm talking to them, what we're talking about, and residents have the same rights. Residents also have a right to privacy during treatment and care of personal needs. So this means that when residents are receiving care, it should be in a private area, such as behind a door or behind a curtain, and not in an open space or, with the door open. examples of this scenario would be if someone's administering care in a common area or somewhere that others may see, or if they are in the residence room but the door's open and the curtain's open, because this really is just to protect a resident's dignity. Aside from people not being able, people shouldn't know what kind of treatment or medical care they're receiving. It's just dignity that residents have the right to privacy when they are receiving care, and to not have anybody walking down the hallway see. Next slide, please. The next thing I wanted to talk about is dietary rights for residents. And we wanted to include this because I think this is something that is so important. This is something that, residents are very focused on, because food is one of the most important things, just as it is for the rest of us. We like to receive food that we enjoy, that it is cooked the way we like, and we like to have options. Nobody would like to have the same thing every day, or to have, food that they don't like, or it's cooked a way that they won't eat it, because food is so important, not just, for nourishment, but also because it is one of the things that residents have a choice in. It's one of the things, we always have a choice in what we put in our body. So it's something that's so important. Residents have a right to choose what foods they do and do not receive. So someone from dietary should be speaking to them regularly and during their care plan to get an idea of what foods they do and do not like, how they like things cooked, and any other dietary preferences. And this is so important to, regularly speak to residents, because, just as the rest of us, our preferences in food change, what we like, how we like things cooked. And it is so important to maintain these dietary cards of what residents do and do not like. So we're making sure that they're getting food that they like, and they're eating, and they're not losing weight. Residents also have the right to have an alternate meal and have options of, what kind of meal they would like. So there should always be choices. We always like to have choices. Staff should be presenting a resident with a menu and asking them, what they would like. There should be options. They shouldn't be just given, whatever somebody decides that day. They should know in advance, that they can choose one option or the other. And if for some reason they choose to have a different food, they have the right to do that. Whenever the tray is brought to them, if for some reason they don't like how it's cooked, or they don't like this specific food or specific brand, they have a right to choose to have something else if they just don't like what they're presented. And they can choose an alternate meal that should be similar to the main choice. So if they are offered, if for dinner they are having a good warm meal, they shouldn't just be given a sandwich as the alternate option. Residents also have the right to choose whether to follow or not to follow a special diet. So often a doctor will order a special diet for a resident, and they have the right to choose, as they do with any other doctor's order. If the resident does not want to follow the special diet, they have the right to refuse it and request the typical meal, or they can choose to not have certain foods withheld from them. So next slide, please. Okay, I just wanted to say thank you for everyone joining us today and taking the time to educate themselves about resident rights. Rights are very important for our residents. If you have any questions, please do not hesitate to contact us. We are available to speak to staff, family, community groups, anyone that would like to speak to us. We would be happy to talk to you about any rights that were not addressed today. And our contact information is on the screen. Wayne Anne is the Gateway region. Her number is 606-755-0006, or you can reach her at wcaudle@lablaw.org. And I am Amanda Hamilton, the FIFCO Long-Term Care Ombudsman. I can be reached at 606-780-2258. My email is ahamilton@lablaw.org. Thank you.